Sorry. Yeah. Morning, everyone. Yes, Mr. Beer.
Good morning, sir. Good morning, Ms. van der Bogerd. We finished yesterday with some questions about the Post Office's management of Second Sight. Do you recall? Can I ask you to start this morning some questions about some other significant events that were going on whilst the Post Office was managing Second Sight? It's the case of the late Martin Griffiths that I want to ask you about. You tell us in your witness statement, I'm not going to ask for it to be turned up, it's paragraphs 149 to 158, about your involvement, quite significant involvement, in the case of Martin Griffiths. Is that right?
Yes.
Can we start with some background information, please? Firstly, Mr. Griffiths was the sub-postmaster at the Hope Farm Road Post Office in Great Sutton, Cheshire. Is that right?
That's correct.
By the time of his death, he had been the sub-postmaster there for some 18 years. Is that right?
I don't remember exactly, but it sounds about right.
A series of shortfalls had arisen at the branch, or were said to have arisen at the branch, and Mr. Griffiths had been accused of being responsible for them.
That's correct.
Right? And notice of termination of his contract had been served on the 3rd of July 2013.
Correct.
Mr. Griffiths and his family suggested that it was the Horizon system that was responsible for the losses.
Yes.
On the 17th of July 2013, Mr. Griffiths asked for his case to be put before the Post Office Board. I appreciate you wouldn't have received this letter at the time, but I just want to show it as background to what did happen.
Yes.
Poll 0014 5768. Thank you. We can see this is a letter from Mr. Griffiths. If we just scroll down, we can see it at the foot of the page, Martin K Griffith. And we can see at the top of the road, at top of the letter, it's addressed to Glenn Chester, the agent contract manager. In your previous roles, had you come into contact with Mr. Chester?
Yes, I had.
And so he was a working colleague of yours, is that right?
On and off over the years, yes.
It's the 17th of July 2013, and Mr. Griffiths writes to Mr. Chester, as you're aware, I have been a sub-postmaster for 18 years, and prior to the Horizon computer system, I enjoyed a satisfactory post office business. For some considerable years, I've been accused of wrongful accounting. Over the last 15 months alone, February 2012 to May 2013, more than £39,000 is deemed to be my shortfall, an average of £600 a week. This surely cannot be correct, but the notifications from the Post Office state this is the case. This worry has affected, and then there's a redaction, and plans for retirement have had to be postponed. I've not had a break in my business hours for more than 4 years to keep a tight rein on the office. The financial strain on myself and my family is devastating and continues on a daily basis. On the advice of Mr. Alan Bates of the JFSA, I've been advised to contact my local MP regarding the recent media coverage on BBC News and in the Telegraph regarding the investigation into the errors discovered by Post Office's Horizon computer system. I believe the Post Office has a board meeting next week after all the media coverage and would like my particular case to be considered along with the many others in a similar situation. Now, I don't think you would have got this at the time, is that right?
That's correct. I've seen this this morning.
Yes. And so this letter of the 17th of July, just fitting this together with our chronology, would have been just before the board meeting that I think you do know about, the Post Office Limited board meeting, at which the issue of the Second Sight report and what the post office was to do about it was to be discussed. I think you did know about that.
Sorry, I can't remember, but probably yes.
It was the one where, did you know about this, the one where Susan Crichton was made to sit outside on a chair?
Okay, I'm aware of it now. At the time, I wasn't aware that was happening.
And so you didn't know that she was kept out of the meeting. It was proposed that she present a paper concerning what the post office should do in response to Second Sight. And instead of her presenting her paper, Miss Venables presented it, and she was sat outside on a chair.
So I only became aware of that listening to Susan's evidence this week.
That wasn't something that caused the stir at the time.
Susan leaving, yes, but there was very little information around the background to that or the reasons for that. Speculation around something to do with the Second Sight, but nothing. There was no messaging. There was no confirmation to us as to the reasons why.
Okay, that letter can come down, and just moving it forwards a fortnight. On the 31st of July, Mr. Griffith's mother wrote to the post office. Can we just look at that, please? Poll 0014 7157. I think this is also a letter that you've been shown this morning.
This morning, yes.
And this is all just background, some context for the inquiry. If we look at the foot of the page, we can see it's from Dorene Griffith, Mrs. Griffith, who I think was in her 80s at this time.
Yes.
And if we look up, it's again to Mr. Chester. I write to you as the parent of Martin Griffiths, despite knowing that you say I'm not part of the said sub-post office. My son has been under severe pressure, and I personally had to take on more work in the retail side of the business, including providing financial support of the shortages. I think you later learned, is this right, that Mr. Griffiths' parents had been putting money into the business, tens of thousands of pounds, to try and balance the books.
Yes, I'd learnt that later.
So they've been using their savings, I think you learnt later, their life savings to try and balance the books.
Yes, that's what I learnt, yes.
Yeah. The so-called shortages over many, many months have been repaid, mainly by myself and husband. Although you can continue to say there's no fault in the Horizon computer system, we eagerly await the results of the ongoing investigation being undertaken by Second Sight regarding software errors. Your letter of the 3rd of July stating termination of Martin's contract, I feel is very harsh. Kevin Bridger has compounded the severe problems, adding insult to injury, and I mean injury, by requesting a fine of £7,600, which represents 20% of the robbery with violence, which occurred in May. It was due to the identification of the culprit by a member of staff that the police were able to make a quicker arrest, and subsequently the robber received an 8-year jail sentence. This request for £7,600 suggests insufficient security at the post office, and we will seek legal advice to refute this. I'll come back to that in a moment, what that's referring to. If, as has stated, my son is terminated on the 3rd of October, that's 3 months from the 3rd of July letter, what is the position of the incoming sub-postmaster regarding the £18,000 a year overheads? At present, this is shared between post office and the retail business. Therefore, a legal arrangement needs to be made. With regards to your outstanding figures for repayment, only £3,600 odd remains, as the £3,000 odd plus £200 was repaid at the end of June. I await to hear your comments. Now, the reference to the robbery there, if we can just look at that, please. I think you now know, and you found out at the time of Mr. Griffith's death, that there had been a robbery at the post office. Is that right?
That's correct.
And 2 armed robbers took over £50,000 from the post office. If
Yes.
we just quickly look at the circumstances of that, poll 0034 2530. Thank you. This is a security report. You can see it's dated the 10th of May, and it's about the robbery on the 2nd of May. And although it's quite a long document, I just want to read a summary of what was found on investigation. And if we look, please, at the 3rd page. Sorry, it's the 4th page then. Yes, thank you. At approximately 5:25 on the 2nd of May, Martin Griffiths and his clerk Julie Griffiths, no relation, were on duty and were putting all the cash and stock away. Both safes were open. Mr. Griffiths was stood at the secure door, which also housed the parcel hatch. The postman had arrived to collect the mail. Mr. Griffiths had put around 2 mail bags outside of the secure door, and the postman had taken these out of the office to his van. As the postman re-entered the branch, 2 masked men wearing dark clothing, one with a balaclava and one with a stocking over his head, burst in and pushed pushed the postman aside. Mr. Griffith stated he was stood at the secure door with the door open so he could hand the daily work and gyro pouch to the postman and get him to sign for the paperwork, and went over to the secure door. One man tried to pull the door open, while the other man attacked the screen with a sledgehammer. If we look, I think we can see that in the photograph. Mr. Griffiths attempted to get the door shut, at which point he believes he was hit on the left hand with some sort of metal bar, possibly a crowbar. At this point, Mr. Griffiths stopped fighting and allowed the 2 men into the secure area. At this point, the assistant, Julie Griffiths, had crouched down and hid behind the coin safe. Thank you, that can come down. I think the post office determined that Mr. Griffiths was culpable for the robbery.
I think that was the assessment in terms of applying, as Doreen said, 20%. I wasn't sure how much it was, but...
Well, initially, I think they found him entirely culpable for the robbery, for breaching procedures, and required him to repay £38,000. Some of the money, I should say, I think £15,000 had been recovered from the robbers by the police. They'd actually found them because of the information that Julie Griffiths had provided. And then that amount for which he was found to be to blame, £38,000, was reduced to £7,500. Yes?
Yes.
And so the post office was blaming him for the robbery.
For not complying with certain procedures at the time, yes.
I.e. leaving the door open whilst the mailman came to collect the gyro pouches.
So I think it was the door, and also the time lock on the safe was unset, I think. And that's from looking at the papers. I didn't know about this at the time.
Okay. On the 23rd of September 2013, I think you know that Mr. Griffiths drove his car to a lay-by on the A41, got out of his car and deliberately stepped in front of an oncoming bus.
Yes.
He was very seriously injured, taken to hospital and remained in a coma for about 3 weeks.
Yes.
On the 11th of October 2013, his life support machine was switched off and he passed away that day. It was later concluded by a coroner that Mr. Griffiths had taken his own life. I just want to see what happened within the post office when it was notified of what happened to Mr. Griffiths. Poll 0016-2068. Can we look at page 4, please? And scroll down. And again, please. On the 23rd of September 2013, the day that Mr. Griffiths walked in front of a bus, at 5:02 p.m, Mr. Alan Bates emailed Paula Venables, Susan Crichton, you and Andy Holt, copied to some other people, including Mr. Arbuthnot and Joe Swinson. With the subject, Post Office, read this. This afternoon I received the following email. It's a prime example of the thuggery being exerted on defenceless sub-postmasters as the Post Office deny legal representation by arrogant and uncontrolled Post Office personnel. Despite assurances from on high that this type of thing is in the past, it's clear from Post Office's actions it's still alive and active through the ranks. And then the email he received. Hello, Alan. I'm writing on behalf of my son-in-law, Martin Griffiths, who's recently been in touch with you about the treatment doled out to him by the hierarchy at the Crown Office in Chester. He had an armed raid in May, and the faceless wonders at the Crown Office have intimated he was culpable. Had him at the Kangaroo Court, where he was not allowed any representation of his own. He was a broken man then. However, he was sent for last Friday to attend a meeting with the Crown Post Office personnel again, and all week he has clearly not been himself. This morning he drove off to work, got out of his car and walked in front of a bus. He's dangerously ill in hospital at Liverpool. The Post Office had driven him to suicide. All the family are at the hospital. I'm alone waiting by the phone for further news of him. I would urge you to publicise this, another incident that's been caused by the bully boys at the Crown Office. May God forgive them. Mr. Bates continues, I'm aware of Martin's case, and I know he was terrified to raise his shortages with the Post Office because of just this type of thing happening to him. But the Post Office got him in the end. Regardless of what may or may not have occurred to him, why did the Post Office have to hound him to the point of trying to take his own life? Why? Despite numerous warnings of never to attend any discussion with Post Office without legal representation, Martin, trying to be helpful, didn't take anyone with him, as per the conditions the Post Office demand. If the Post Office cannot control their personnel, then at the very least they can do is authorise and insist on a sub-postmaster taking legal representation with them to any meeting with the Post Office. I'm very, very angry about this. And as per the wishes of the family, I'll be contacting many of the media contacts we've built up over the years. Back to page 4, please. Scroll down. We can see that Miss Crichton forwards the email to Roger. Can you find help out the facts? We really need them this evening. A couple of minutes later, Mark Davis says we must get details of this evening. Mr. Gillibrand says, I've spoken to Roger, trying to find out the details. And then if we scroll up a little bit, just so we can see the bottom of page 3, we can see an email that distributes this to you, yes, this chain to you, from Mark Davis, yes?
Yes.
And Mr. Davis says, thanks. Susan, given the potential media element, please can we line up a specialist media lawyer in case we need urgent advice this evening? So the immediate reaction, you agree, was not, is Martin Griffiths all right? What about his health? Was it?
Not at this point in this email chain, no.
The immediate reaction was not, what can we, the Post Office, do to help this man's family, was it?
Not at this point.
What about his wife and his children? What about his elderly parents? What about his sister? Should we get somebody down to the hospital? That didn't happen, did it?
Not getting somebody down to the hospital.
No, the first thing was, let's get a media lawyer.
So that's what Mark has said here.
Is that what it was like working in this organisation at the time? It was all about brand reputation, about brand image.
So my concern here, when I got to, so the first I knew of this is, so it came in separately, I think, from, I think Martin's sister So there was a separate report to Glenn of what I heard originally was a traffic accident. We didn't know that he'd actually deliberately walked in front of the bus at that time. So obviously there's some more correspondence because I've said, so Roger Gale was actually running the Crown network at the time.
This email chain tells you he walked in front of a bus.
No, sorry, it's something that came in separately. I'm saying there's two kind of parallel notifications to me. When I saw this, and I didn't know Martin, this was my first involvement in it, then I was genuinely concerned for the family, which is why I got involved going forward.
I think you're talking about much later. I'm asking about what on the face of the documents, the immediate reaction of the post office is.
I mean, that is the immediate reaction, like it's on the email.
And help us. Is that what it was like working in the post office at this time? That the first thought was, we need a media lawyer here.
I don't think it's the first thought. It was definitely a consideration in everything that we did around PR and the comms element. It was always a consideration. And
why was that an important consideration? Brand image. There's a man that's walked in front of a bus here.
So
one of your sub-postmasters.
Sorry, in all my time with Post Office, from very early on, I was very conscious that PR was very important, and everything had to be, so the involvement it was the comms team. So Mark was the head of, he was the comms director at the time, and that clearly is his area, and that's what he said.
If we scroll up a little bit, you reply, this is not related to the Crown branch, but is a sub-postmaster case. I'm talking to the contract advisor. Is that Glenn Chester?
It is, yes.
And then you emailed Mr. Chester within an hour or so saying, Glenn, this is what we're dealing with, and the reason I need to talk to you. What did you mean, this is what we're dealing with?
So I think I might have reached out and left a message to say I need to talk to you urgently. And that's just me forwarding the information to him. No, he separately, I think, at this point already knew.
But this is what we're dealing with. Were you saying that it's because the hierarchy of the post office, including Ms. Crichton, Ms. Bennells, were involved in this now?
No, what I was saying is I need to talk to you. This is the information I have, and that's all the information I had at that point. So I was simply forwarding it to him. I say I'm sure I left him a voicemail to say I need to talk to you urgently.
And why not Glenn or Mr. Chester? What's being done for the family here?
So, I mean, this was me just forwarding it very quickly because I wanted to understand what has happened here, because I was not cited on this case at all.
Thank you, that can come down. About a year after Mr. Griffith's death, his daughter wrote to the post office, and that was forwarded to you, wasn't it?
I had an email from Lauren, yes.
Can we look, please? Poll 0030 6234.
Mr. Beer, I don't know whether it's just here, but every now and then we're not quite catching what's happening, so could everyone speak up?
Sorry, I'm not speaking loud enough, okay?
Maybe that it's not affecting the hall, but for whatever reason here, every now and then the words tail off, all right?
Sorry, sir, I'll speak louder.
Is it both Ms. van den Bogerd and me?
It's both sides, actually.
Okay,
yeah.
It might be to do with the amplification.
Yeah.
So we were looking at, thank you, we've got it up on the screen. So we're now about a year after Mr. Griffith's passing, and his daughter, Lauren, wrote to you. She says, Angela, after speaking with my mum yesterday, I'm emailing you to let you know how disgusted we are with the treatment our family has received from the post office. As you're well aware, it's now been almost a year since we lost our dad. We hold the post office solely and wholly responsible for what happened to him. As I'm sure you can imagine, our family has had an extremely tough year with what I consider no support from the post office. My dad was the main income earner for our family. Without this income, my family's been struggling to get by financially. My mum cannot work in the shop of the post office due to the severe ill feeling she holds for it, and redaction with the stress and workload of keeping the shop open. Considering the financial size of a business such as the Post Office Limited, I cannot comprehend how our family has not been supported or compensated this past year. I firmly believe we wouldn't have received this kind of treatment from any other large corporate organisation. I understand you're putting what you discussed with my mum yesterday in writing to her. It appears from what I've heard that you're offering the £140,000 compensation payment on the condition that we drop any action or legal recourse with the Post Office for any further compensation for its wrongdoing. No amount of financial compensation could replace the fact that the Post Office has taken our dad away from our family. But simply put, £140,000 compensation for our dad's life is simply disgusting. I request that you escalate this matter and you forward this email on to the relevant parties within the Post Office. As stated above, this has dragged on now for almost a year. The way in which the Post Office has dealt with this matter has been inadequate and incompetent. We'll get back to you once we've received your response in writing. I'd also appreciate a response to this email. Was it right that you were offering £140,000 compensation on condition that the family drop any action or legal recourse?
So what we were offering here was the equivalent of a network transformation payment.
Just explain what the equivalent to a network transformation payment is.
So there's quite a lot of correspondence before we get to this email, which I don't know if you're going to go to, but gives the background. So at this time, Post Office was running a network transformation program, which was compensation payment for postmasters for loss of office, to leave their branch, for it to be transferred to a new postmaster, and it was all part of a refurbishment plan. So the compensation payment for that loss of office, I think, was equivalent to 26 months remuneration, and that was a set calculation that was being offered to postmasters throughout the network. So
just briefly then, why was that the loss of office figure determined to be the appropriate figure to offer Mr. Griffiths' widow and family?
So what we did here, or tried to do here, was prior to Martin's death, he had registered an interest in leaving the network via the network transformation program. But when he was served 3 months' notice, that deemed him he was no longer eligible because he didn't have a contract, or he was on notice of his contract. So at that point, he wasn't eligible any longer. So what I tried to do here is just go back to the situation of processing the network transformation payment for Gina Griffiths, so that she could have what he was trying to do is have payment for loss of office in terms of him leaving the network. So what Lauren is saying here is as if this is packaged as a payment for his life, and that was never the intention. And I did respond to Lauren, because I had met with Lauren previously. So after Martin's death, I'd met with Gina, his wife, and his mother at the same time.
That was at a local pub.
At their request, yes. At their request, because it was more private away from the office. So I met them at the local pub, and it was private. And what I'd said, and I was generally to give them as much support as I could. And I'd said that I would be very happy to meet with anybody else from the family if they wanted to talk to me. And Lauren asked if I would meet with her, and I met with her in London because that's where she was working. So I met with Gina and her mother-in-law in the November, and I think it was the same month I met with Lauren as well. And I met with Gina Griffith and her brother on the 1st of September, which is what's triggered this email from Lauren.
But the way it was being put by you, it was your idea, wasn't it?
To get the payment I wanted, yes. So I was concerned that so there was clearly the financial pressure on the family because, as they said here, Martin was the main earner. I mean, I didn't know that at the time, but clearly he was the postmaster, and I was trying to facilitate a way for that payment to be made because that was what his intention was prior to his death.
But it was going to be conditional on dropping any claim that the family had against the post office, wasn't it?
So the way that the network transformation payments were structured, it was subject to a non-disclosure agreement, and it was a final and full settlement of all claims both ways. That was the structure of that network payment. So all I was looking...
But that's for postmasters who are just leaving the business because of part of the post office's closure program, essentially. I mean, I know it's called network transformation, but
yes,
it involved closing thousands of branches.
Yes, but that's what this was intended to do. I was trying to just replicate that for Martin Griffiths and Mrs. Griffiths, so that we could facilitate that payment. So the intention was never linked to a payment for his loss of life. That was never the intention.
But they had a live claim with Second Sight, didn't they, that was being mediated about the losses, the alleged losses, the shortfalls.
So there was an application into the scheme, yes.
This was going to be conditional on dropping that too, wasn't it?
That was the broader piece of the network transformation. It covered everything.
What does that mean? That's just word soup. That
Sorry?
was the broader piece of the network transformation thing.
So
what I ask you, Ms van den Bogerd, is this payment was going to be conditional upon the family withdrawing the claim that they'd made under the mediation scheme, wasn't it?
Yes, because that's the way the network transformation payment was set out. Now, having met with Gina and her brother on the 1st of September to discuss what that would look like, I had some... So in that conversation, they'd asked me to consider, is there a way that we could at least facilitate that the investigation into the case and allow some time. So there was, out of that conversation, then we structured a way forward that would allow Gina to, we could try and facilitate the network transformation, the transfer of the post office to an incoming postmaster. And the discretionary payment we would put on hold, whether she wanted to accept or not, subject to her receiving the scheme report. And that's what we structured to allow her the opportunity to decide whether she wanted to accept this discretionary payment or not, but she could still go ahead with the transfer of the post office.
It was important to the post office to ensure that the Griffiths claim that had been lodged with the mediation was withdrawn, wasn't it?
No.
The last thing the post office wanted was the bad publicity of the Griffiths claim being progressed through the mediation scheme, wasn't it?
No, that was never my consideration. My consideration was to support the family.
Can we look, please, at poll 0030 6172? I think this is a draft letter that you prepared for sending to Mr. Griffith's widow, Gina, yes?
Yes.
And if we scroll down, you say Martin was not eligible for a network transformation leavers payment. He'd been served 3 months' notice of contract termination. In recognition of his service, the Post Office would like to offer you a discretionary payment in the sum of £140,000. That's equivalent to the sum offered to sub-postmasters who choose to leave.
Yes.
I note you've made an application on behalf of your husband to the initial complaint review and mediation scheme. When a discretionary payment is offered, the normal process is for it to be is for it to be made in full and final settlement of any claims that a sub-postmaster had against Post Office Limited. Just stopping there, this says that was normal, but the terms on which the Post Office could make this offer were completely discretionary, weren't they? It was up to the Post Office to decide the terms on which the offer was made.
Yes.
It could be on any terms the Post Office choose to put forwards.
Yes.
And the normal situation that you're referring to there was a common or garden postmaster who was simply deciding to exit the business as part of the programme, as part of the Post Office's general closure programme.
Yes.
These are rather different circumstances, aren't they?
I mean, it's very tragic circumstances.
And therefore very different.
Yes.
And so why were you saying this was all normal? That the payment has to be in full and final settlement of any claims, whereas this was a very different situation here. It was an outstanding mediation claim.
So this was being done in parallel. I said what I was trying to do was facilitate this payment to Gina and the family at that time. Anything to do with the scheme claim would have taken a lot longer. I mean, at this point, the application into the scheme had been quite delayed from Gina and her advisors at the time.
You continue, in this case, acceptance of the discretionary payment will therefore come with a waiver of any claims under your application and bring that application to a close, i.e. that's the application in the scheme, yes?
Yes.
And then you continue, your preference is to see the outcome of the investigations into your application before making a decision on how to proceed. But you also wish to move forward with the sale of your branch to accommodate both these objectives. The Post Office agrees to pay the discretionary payment subject to the following conditions. 1, Post Office finds a suitable alternative operator. 2, the successful alternative operator enters into a legally binding but conditional contract. 3, you sign and return the attached confirmation of transfer document confirming you wish to transfer the branch to the new operator to proceed immediately. You have the option to accept the discretionary payment at the point of the transfer completing, or alternatively, you can defer the discretionary payment for over the page 6 months for you to review the findings of both the Post Office and Second Sight's investigations into your application, both of which should be with you within the next 2 months, and if appropriate, mediate your application with the Post Office before deciding whether to accept the discretionary payment. Is that what you were referring to earlier?
Yes.
5, you sign the response slip. 4, you sign the response slip. 5, you sign and return the attached withdrawal notice. Can I turn then to what next happened by looking at poll 00219796. Which is email advice to you from Roderick Williams in January 2015. Saying, please find attached the draft settlement. I'm not in the interest of time going to look at the draft settlement. Setting out the basis on which the Griffiths Hope Farm Road has been resolved. agreement has been drafted to resolve all claims that either the deceased Mr. Griffiths or the applicant Mrs. Griffiths may have against the Post Office. Equally, the agreement resolves any claims the Post Office has against the deceased or his estate, i.e. we will not be able to seek recovery of any outstanding losses in the branch accounts or incurred through the robbery at the branch. Please let me know if this is not our intention. Was that still a live question? Bringing a claim against Mr. Griffiths' estate for the robbery?
So that was still open at this point, yeah.
You're still thinking of suing his estate?
No, it hadn't been concluded. So at the point of which, of Martin's death, then if I remember correctly, the outstanding debt was still live on his account, and the robbery of £7,000 or whatever that was still, yeah. But from my intention was never to recover any of that, and we didn't.
He continues, you'll note from paragraph 2.1 that Mrs. Griffiths has agreed to stage payments, which we asked for as an incentive to Mrs. Griffiths, maintaining confidentiality. As drafted, if Mrs. Griffiths were to breach confidentiality, we could stop any further payments, but not recoup sums already made. Please let me know if you'd like the agreement to be amended to give us that right. Mr. Williams is saying that the provision in the agreement for stage payments to Mrs. Griffiths were included as an incentive to her to maintain confidentiality. That was important for the Post Office, wasn't it?
It was from Roderick. I mean, that was nothing I'd ever discussed. That came... So I wasn't involved in the initial... Sorry. Roderick was drawing up the settlement agreement with Mrs. Griffiths' solicitor. I'd had an earlier conversation with Mrs. Griffiths' solicitor when Gina contacted me via her solicitor to see if we would actually settle the case with her. And this is after the meeting. So I had the meeting on the 1st of September. I'd written the letter and sent that to Mrs. Griffiths, and on the basis of the conversation I'd had with her and her brother on the 1st, I didn't anticipate that we would be proceeding with the payment, because I got the impression that she wanted to wait to see what the outcome of the investigation into the scheme case was.
This is about a different issue. This is about the Post Office staging payments to act as an incentive to her. A sword of Damocles hanging above her head. You don't get any more money unless you keep quiet.
So that's
what this is, isn't it?
So that's what Roderick was setting out. And I presume he'd had that conversation with his solicitor.
No, but he must have had some instructions.
He didn't from me at that time. He'd already had that conversation.
With who?
I presumed with her solicitor, because he was dealing directly with her solicitor.
So are you saying that Mr. Williams thought that including a clause to this effect would be beneficial to the Post Office and therefore included it in the draft?
That's my understanding.
Right.
Yep. And
did it remain in the settlement agreement?
It did, because what he was saying...
So that must mean that the Post Office, and from what I gather you said, you approved that?
Yes.
Right, thanks.
Did you see anything unsavoury in using money as a way of ensuring Mr. Griffiths' case was hushed up?
I mean, it wasn't something that I discussed with Gina and her brother, and it didn't even enter my head that we would be going down that road. This was the first I heard of it from Roderick, and the fact that he said it was accepted, then I just allowed it to continue.
So you agreed with the idea that we should use the drip feeding of money to the widow as a means of ensuring that she keeps it hushed up?
I went with what he'd suggested here, yes, I did.
Do you see anything unsavoury in that?
I mean, my concern at the time was facilitating that payment to Gina. That was my, because I'd had to have lots of conversations to get to this point, and I'd structured it, I felt, as best I could to give her the flexibility to be able to transfer the post office, which is what she and her mother-in-law wanted to do, and give her the option to be able to consider the outcome of the scheme investigation before her making a decision going forward. So at that time, I'd felt that I'd done as much as I could to facilitate that and to help the family financially.
At the point that Mr. Griffith died, there was a live dispute about the cause of the losses in his branch, wasn't there?
Sorry, when you mean a live dispute, what do you mean?
We've seen some
In terms of
letters
scheme?
that he had written to the post office and his mother had written to the post office saying that the cause of those was Horizon.
So there's two things in parallel looking at this, and as I wasn't involved prior to notification of Martin walking in front of the bus. Was there the case had been concluded with Glenchester, and therefore that he'd been served 3 months' notice. And then what we had going in parallel was the scheme, which was the route in for us to look at his case.
In the scheme, it was being said that the losses were caused by Horizon, not by the late Mr. Griffiths.
When we got to investigating that, yes.
Wouldn't the correct, the respectful, the compassionate course of action to be to provide the family with a discretionary payment and allow the claim under the mediation scheme to proceed to its conclusion, so that the rights and wrongs of the cause of the losses in the branch could be established under the scheme?
So what I was trying to do was to facilitate the payment to Gina, and the best route I could get the business to agree, was to do that through the network transformation payment, because that mechanism was already set up, and that's what I tried to do. I tried to give Gina the flexibility so that she had time to consider what the outcomes of the investigation by Post Office and Second Sight were before she needed to agree whether she wanted to pursue the claim through mediation or whether she wanted to accept this discretionary payment.
Do you recall that the JFSA asked the Post Office not to approach Mrs. Griffiths without involving them?
I do recall that, yes.
Did you ignore that request?
No, Gina approached me.
And you thought that there was no need to tell the JFSA about that?
So in terms of the confidentiality, that was with Gina. It wasn't my place to tell JFSA. Gina had approached me via her solicitor, and I respected the fact that she wanted to do that privately, and not in the arena of the scheme. So I went with her wishes.
Would you agree that the JFSA only discovered that you had negotiated this settlement with the family when the working group was notified that the case should not come to mediation because it had been settled?
So my expectation was that Gina would have spoken. I mean, she had been in touch with Alan Bates throughout this situation, and she was having those conversations. It wasn't for me to tell JFSA of what Gina was considering doing. That was a private matter, and I respected the confidentiality of Gina in doing that, so that wasn't for me to pass that on. The formal route was the signing, there was a draft withdrawal notice for Gina to sign if she wanted to accept that payment, and that was the process that was in place. But it wasn't my place to have that conversation.
So is the long and the short of it that you procured a settlement on the basis of £140,000 payment, which figure applied to a completely different type of loss? You ensured that there was a non-disclosure agreement attached to that settlement, that you agreed to the staging of payments to act as an incentive, using money as a tool to keep the matter hushed up.
So it was never to keep the matter hushed up. Any settlement agreement that Post Office ever entered into was done with a non-disclosure agreement.
Why?
Because that was just the way they operated. That was always the way.
But just why? Just take a step back from the answer of an automaton. Why does the Post Office always insist on non-disclosure?
Because that's how they tied up the agreement. And that,
Yes, but why?
Well, I just accepted that was the standard approach in all settlement agreements, and that is how they'd always operated and still do today, I believe.
Because it likes secrecy.
So they wanted to settle the claims, and they wanted to draw a line under that engagement. I'm not talking about this engagement, by the way. I'm talking about, in general terms, that was how they'd always proceeded. Now, in this case...
So I should say the document can come down.
Sorry, can I just in this case, the £140,000 was the payment for the network transformation payment. I believe that the actual settlement was different, but I'm not party to what that looked like, because that conversation had happened between Roderick and her solicitor.
Thank you. I'm going to move on to a separate topic, my second topic of this morning, which is the Lepton Branch and the Helen Rose report. I think you were first told about the Lepton Branch issue in early 2013, is that right?
So that was when Ron was doing the spot review on the Lepton Branch.
Let's just look at some emails to nail it down. Poll 0014-1489. And can we start on page 2, please? Can we see an email there from Mr. Warmington to you?
Yes.
Of the 23rd of January 2013. Concern reported by John Armstrong. Second sentence, we have more on this case, which I'll send you soonest, but the following email trail should give you a flavour of it. John Armstrong is one of many sub-postmasters who have referred to communication fail-induced automatic, i.e. Horizon-generated, transaction reversals, where they're not advised of those reversals by Horizon and only get to know of some of them much later. As you all know, Fujitsu have rejected assertions that communication blips can give rise to lost transactions. We're seeing many of those assertions, and some like this one, that might just be true. Apologies for the fact that in the first email chain, John Armstrong's summary of what happened and of the amounts involved was slightly out. We're at the stage where we need the Post Office to assign us a point of contact with clear instructions on who to CC to get to the bottom of these quite complicated transactional issues. If we have to wait for the Fujitsu data to be supplied, unravelled and examined for each one, we'll not be able to clear them before next Christmas. So it's a lost transaction issue, yes?
Yes, it was a reversal.
Just explain to us what you then understood the issue to be. You've described it there as a reversal.
So the actual detail of this case, or just a reversal?
The detail of this.
Okay, so my understanding of what happened here is that a customer came in to pay a BT bill, phone bill, and in the process of processing that payment, the system lost connectivity.
So the communication fail.
Yes, so the screen went blank and the postmaster was unable to process the payment. So what he did, in the interest of dealing with the customer, he actually took the money and stamped the the customer's receipt to say that you've paid the bill, and that the customer had left. So that was, but when the system came back up, I'm sorry, I'm trying to remember the detail here, the transaction was actually reversed, which meant that even though the customer had paid the bill, as far as they were concerned, the bill had not been processed through the system, and therefore, as far as BT would have been informed, that bill had not been paid.
Thank you. And if we go forward to page 1, please. Foot of the page, you reply, sending it on to Andrew Wynne. And why were you sending it on to Andrew Wynne?
Because Andy, as I know him, he had dealt with this situation, I think. So he was the dispute resolution manager in Chesterfield, and I wanted to talk to him about what he'd seen in this case.
And the idea that transactions could be lost would have been rather important news for the post office, wouldn't it? It's a significant problem.
So understanding what had gone on in this situation, yes, this is the whole point of what Ron was trying to do and I was trying to support, the information flow to him so that we could understand what had happened here.
And the point that Mr. Warmington was making was that there was nothing to alert the sub-postmaster that the system had reversed the transaction.
That's what he was saying at the time, yes. That wasn't the conclusion, but that's what he thought at the time.
Can we go on, please, to FUJ 00229801? So I should have said, if we just scroll to the top of that page. You sent this on to Helen Rose. Yes. And why did you send it on to Helen Rose?
Because I wanted Helen's support in understanding the information from Fujitsu. So Ron, in the email train, said he was having problems getting, or he had to wait to get the information from Fujitsu. It would take an age. Having, what Helen had done with Ferndown and pulling that information for me a couple of years earlier than that, I went to her to see whether she could do the same so that we could facilitate that information flow.
Thank you. FUJ 00229801. And if we start at page 2, please. You're emailing Gareth Jenkins directly by this time?
Yes.
At the foot of the page. That's it.
That's right.
Thanks for your help. I thought we'd already asked for formal help on this case. If this is not the case, then I do wish to process such a request. Could you advise on the process? I absolutely need to be able to articulate what's happened here. So given that you're probably the person that can help formally, I look forward to our future correspondence. Were you taking the lead here?
So I was trying to get the information from Fujitsu so that we could share that with Second Sight.
And were you taking the lead here?
In essence, yes, because I wasn't aware of what the process was, which you can see from my note, and I wanted to hurry it up.
And liaising directly with Gareth Jenkins?
On the back of, I'd seen some correspondence between, I think Helen copied me into something earlier, so yes, I reached out to try and push it ahead.
Can we move on then to poll 0013 4139? And again, start with page 2, please. So I should have started with page 1, just to, if we go to the top of page 1, you're forwarded the entire chain here between Helen Rose and Gareth Jenkins about Lepton, the branch in which this had originally occurred.
Yep.
With Miss Rose saying to you, email string may be of interest, I'm not really sure where to take this. Happy to try for a change request. I don't want to tackle one small issue when we may need to challenge deeper issues with the way we see data from Fujitsu credence. And then if we look down, please, at the foot of the page. Thank you. The email to Helen Rose from Gareth Jenkins, and then carry on. And then carry on to Helen Rose's email to Gareth Jenkins. I can see where the transaction is and now understand the reason behind it. My main concern is that we use the basic ARQ logs for evidence in court. And if we don't know what extra reports to ask for, then in some circumstances, we would not be giving a true picture. When you read this chain, or this part of the chain, would that have sounded alarm bells to you?
So, not at the time. I mean, I was trying to get to the bottom of what had gone on in Lepton for the spot review. I wasn't familiar with how Helen and that team worked, other than if there was anything unusual or important or anything else, I expected her to be able to raise that through her reporting line.
What the person you had asked within Post Office, the analyst, to do, i.e. liaise with Fujitsu directly to help you progress the issue,
Yes.
had resulted in was a concerning observation by her that the data being provided by Fujitsu for use in court was not disclosing a full picture of transactions, correct?
That's what she's saying, yes. She had some concerns about that.
And in her email to you, she said she didn't know what to do about it.
I took that to be about getting the change request sorted. So
to get a change request to, sorry to speak over you,
Sorry.
to get more data.
No. So the change request was in relation to changing the ID on the transaction, so it was obvious that it had not been done by the postmaster or whoever was in branch, but that it was a separate ID, so it was easily identified to that this was a system a reversal rather than a reversal that was initiated by the postmaster in this case.
But go back to the top of page 1, please. In that second paragraph, she's raising a broader issue here, isn't she, with you, saying, I don't know where to go with this. I have discovered as a result of this case that the ARQ logs that we use in court do not show or may not show a true picture. We may not be giving the court a true picture.
That's not how I read this. I read this as, I'm not sure where to take this, happy to try for a change request. So that is how I read this. Now, I don't...
Are you saying that you now recall how you read this?
No, so what I'm saying is that when I read this, then I read that as, I don't know where to go with this, but I can do a change request if you want me to. I've not seen any further email correspondence on this.
You didn't do anything according to the email chains that we've been provided with in response to this.
I don't think so, unless I had a conversation with Helen, but I don't remember. I have seen something else in the disclosure that I did initiate or put on an improvement list to get this change facilitated, although I'd forgotten about that.
To get what changed?
The change of the ID to make it obvious that this wasn't a postmaster reversal, that it was a system-generated reversal.
Because I'm talking about we may be presenting incomplete and inaccurate evidence, but by reason of its incompleteness to the court issue.
So I didn't read that this way. As I say, if I had a conversation with Helen and I don't remember, then I would have said, because I expected her to take this through her reporting line, because this was outside my area of knowledge. I've seen subsequent disclosure that she did do that, and then she produced a report later, but that report, I don't remember seeing that at the time she did it, and I've got no evidence that she sent it to me, although I have seen that I requested it at a later date because I became aware of it. So for me, my take on what she was saying is, I'm not sure really where to go with this, because I'm happy to take it for a change request. That's what I took from this. I'm not really sure where to take this in terms of relation to the evidence, because that clearly would be through her reporting line. That's where she would automatically take that.
Let's see what you say in your witness statement about this, please. It's page 45, paragraph 94 onwards. Page 45, please. And you say document, and you give the character string, which is the email we've just been looking at, is an email to me on the 13th of February forwarding correspondence between her and Gareth Jenkins, flagging concerns that Horizon-based system corrections and adjustment transactions are not clear on credence or ARQ logs, as shown with the Lepton logs. That's one of the issues, would you agree, that it raises?
Yes, it is one of the issues.
The other issue is the presentation of evidence in court proceedings.
Yes, it's linked, obviously, yes.
I cannot recall my response. I've requested a copy of my response to Helen's email, but the post office could not locate this, which indicates that I did not reply to Helen via email. I may have had a conversation with her to discuss the email, but you can't remember. At 95, I did not share the report with or brief others in senior management, board, sub-postmasters or MP on the report. You cannot recall when you first became aware of the report. You've asked the post office for a copy of the covering email from Helen Rose to recipients of the report, but they're unable to locate it. Seem to remember it was brought to my attention by the legal team as they were preparing for the group litigation order. So you think you didn't, we're going to come to the Helen Rose report in a moment, you think you didn't see the Helen Rose report until preparation years later for the group litigation?
I didn't see the report from Helen at the time she wrote it. It was later. I can't remember when that was. I have seen some further disclosure after I put this together that I've asked somebody for a copy of the report, and that would be, I think, in 2014, which would be earlier than going into the litigation, but I couldn't remember at what point I saw it. I definitely saw it, but I couldn't remember when. Okay,
we'll come to that a little later. The inquiry have asked to what extent, if at all, did the matters concerning the ARQ raised in the Helen Rose emails, that's restricted to the emails for the moment, made me or anyone else at the Post Office concerned that past convictions may be unsafe. Whilst I can't speak for anyone else personally, I did not make any connection to the safety of past convictions from the emails from Helen Rose or the Helen Rose report. Whilst I realise this sounds naive, prosecutions were outside my area of responsibility and indeed my knowledge scope. I took no view on how they were put together, other than to be assured they were all done in line with the Code for Crown Prosecutors, etc.
Yes.
So when Helen Rose was raising with Mr. Jenkins and then drawing to your attention the fact that basic ARQ logs are used for evidence in court, and therefore, in some circumstances, we would not be giving a true picture to the court. That didn't ring any alarm bells.
Not for me at the time. As I said, I expected Helen to take that through her reporting line.
You would have expected Helen to take that through her reporting
Yes.
line,
I mean,
even though she was drawing it to your attention.
well, she was only drawing it to my attention because I'd asked her to look into the Lepton case.
So is it one of those things that it's just somebody else's job, Miss van den Bogerd?
Well, it was outside my knowledge scope, as I said, so I wouldn't have had the knowledge to know what to do with that. Helen did raise it through her line, and it was subsequently addressed that way. So, as I say, I don't remember if I had a conversation with her about it, but she certainly did what I expected her to do, was go to her line route to make sure that she expressed her concerns there, and it was dealt with appropriately.
Are you saying that you need a greater, as you call it, knowledge scope in order to realise that it's a serious issue to present incomplete and therefore inaccurate information to a court?
So this is the first time I started getting involved in this. I wasn't, I didn't have the broader view or the broader knowledge, and now I would obviously look at this very, very differently. But Helen was used to doing this. It was Helen's expertise, and she was there to take that through her reporting line.
But you were handling the Lepton issue.
I was trying to get to understand what had gone on with the Lepton issue, yes, and provide that information to Ron in Second Sight.
Did you pass on to Mr. Warmington of Second Sight the fact that the Post Office may be presenting incomplete and therefore inaccurate ARQ data to courts?
I don't believe I shared that email chain with Ron.
Or the information in the email chain?
I don't believe I did. I had numerous conversations with Ron on this particular case, trying to understand what had gone on there, but I wouldn't have discussed the other email chain between Gareth and Helen with him.
Thank you. So could we take our morning break, please, until 11:10?
Certainly. One advantage of being here, Mr. Beard, is that I can start without the latecomers.
Yes. Ms. van den Bogerd, can we move to later in the year of 2013 to see what happened further in relation to the issue that Helen Rose had been asked to investigate, arising from the problem at the Lepton Branch, and look at poll 00146928. And go to page 3, please. And scroll down. This chain starts with an email of the 19th of November 2013 from Ron Warmington to Shirley Hailstones. I think she was a case manager, is that right?
Case review manager, yes.
Sorry, case review manager, you're quite right. On the post office side of the mediation scheme, is that right?
That's right, she was part of my team, yes.
And how many case review managers were there?
2. So she was the north, so there was one in the south.
And Mr. Warmington had copied in Lee Castleton, his partner in business, Ian Henderson. That's Mr. Warmington's partner in business, Mr. Henderson, and Alan Bates, and says to Miss Hailstones, Shirley, I am looking at Lee's source documents now. That's Lee Castleton. We'll scan and send you those you've asked for. In the meantime, here's spot review 18. I'll also locate in Lee's documents, which I have here, the pages that relate to the transactions that Lee claims were entered at times when neither Lee nor his staff were logged in. My thoughts turn to auto-generated reversals as a possibility here. As we've already established, Horizon allocates to each of its own reversals the ID of the staff member who input the transaction that the system, is then reversing. My position on that is that the design is incorrect and that such auto-reversals should always have had attached to them an ID naming Horizon itself, not asserting that the person who keyed the about-to-be reversed transaction and who may not even know that his or her transaction is about to be reversed also processed the reversal. Also seems that in many cases, not only did the originator not know that one of his or her transactions was being reversed, but also never found out that reversal at any later time either. And so what would you agree Mr. Warmington is doing here is raising the Lepton Branch issue in the context of the investigation of Lee Castleton's case?
Yes, he's making a link there and asking and letting Shirley know that.
He's pointing out that it might have occurred at Lee Castleton's branch too. The ARQ data showed transactions next to a branch user ID, but the people at the branch were certain they hadn't performed the transactions, is what Mr. Castleton was saying. At Lepton, it appeared on the face of it as if this was a branch transaction. That's what the system showed, rather than a system-generated reversal. And so he was saying it was possible that the disputed transactions at Marine Drive were themselves automated, despite the user ID of a branch user being shown next to them. That's the point he's making, isn't it?
Yes.
So the Lepton issue is being raised again in Mr. Castleton's case. Yes?
Yes.
And then if we scroll up, please. There is some information that's irrelevant. And then if we go on to page 2, please. Ms. Hailstone's replies directly to Mr. Warmington, cutting out Lee Castleton, Ian Henderson, and Alan Bates from the chain. Can you please provide the transaction logs applicable to the transaction or more detail? And then up, please. Mr. Warmington says, I don't think I've been given these, Shirley, but we'll take a fresh look. Lee, if you still have those, please get them to us. Shirley, at this stage of the process, I think you should routinely copy, as I did, and have again here, the applicant and his chosen professional advisor, Emma Porter, on correspondence. So Mr. Warmington was saying that correspondence of this nature should be copied into the applicant to the scheme, yes?
That's what he was suggesting, yes.
Yes, rather than being excluded.
That's what he's suggesting in terms of direct copy, yes.
Bottom of page 1, please. Shirley Hailstone forwards that chain to you. And then up the page, please. You forward it to the lawyer Andrew Parsons and the lawyer Roderick Williams, asking or saying you'd be interested in your views on Ron's approach here, i.e. copying the email correspondence to the applicant, their advisor, and Alan Bates. Shirley's investigating that case and has legitimately asked Ron for some more information he may have. This interaction, in my view, this interaction should, in my view, not be widely circulated. I'd appreciate your thoughts. So it had been pushed up the chain to you, the fact that Mr. Castleton should be kept out of the loop. You agreed with that, didn't you? So
this was a point of process. So what we'd agreed when we started the scheme is that Ron would be Ron and Ian, second site, would be the liaison directly with the applicants and their advisors, and then linking to us. It was never, it's not about keeping them out of the loop, it was just who was meant to be sharing that information at what point. Now, we'd had feedback from JFSA in the process to say that they didn't want direct contact with the applicants from Post Office because it triggered, it just brought back bad memories. And even later in the scheme, they asked us to remove the post office logo from any correspondence that they sent, so it would just be mediation scheme kind of logo. So this was simply a process point around what's the appropriate way that we should be engaging with Second Sight. And my view is that...
To summarise, you're saying that you had the well-being and health of sub-postmasters at the forefront of your mind, because to be copied in on correspondence with the post office might trigger them. That's what you're thinking, is it?
That was part of it. The other part of it is that the communication back to the applicant should have been done, which should have only been when the case had been investigated. So they'd get a post office investigation report, and then they'd get the case review report from Second Sight. So the process was that they shouldn't, from post office's perspective, be included in all the correspondence in between, because that was just part of the investigation. But it was for Second Sight to liaise directly with the applicant and the advisors.
Was it that you wanted the post office to appear helpful whilst actually preventing the sub-postmasters from gaining access to information in the course of the investigation of the case?
Not at all, because the access they had was to Second Sight, who had all the information.
So there wouldn't have been a problem with Second Sight forwarding this email?
No.
It was just the fact they were copied in?
Yes, it was just
to a chain.
It was just a process point.
You wanted to erect information barriers, didn't you, to prevent the sub-postmasters from finding out the truth from Second Sight, didn't you?
No. Second Sight had the the ability to liaise directly with them and get the information flow directly. So it was nothing about stopping information at all. It was just purely a process point about who should be doing that.
Can we move on, please, to 2014, poll 302-9709. And start with page 2, please. And if we go to the foot of the page, please. There's an email from Mr. Darlington, who is a member of Howe & Co. Solicitors, yes?
Yes.
Emailing Mr. Warmington, and then a general post office group email. Do you know what that was on the copy list?
No.
He says, "Dear Ron, as Pretty has stated in her last sentence, we're seeking a stay on the time limit on all cases under review due to the implications of the Post Office's non-disclosure of system-generated transactions and Horizon's integrity issues. The Helen Rose report is of critical significance to all cases. The information contained within it is a compelling case for such a stay in its own right. When combined with the Andy Wynne Alan Lusher email in the case of Ward, which explicitly states that Fujitsu can remotely change the figures in the branch without the sub-postmaster's knowledge or authority, the case for a general stay is overwhelming." So here, this email is bringing together two strands, isn't it? One that we looked at yesterday, the Wynne Lusher email about remote access.
Yes.
And secondly, the issues raised in the Helen Rose report. And then if we scroll up, please, we can go past that email onto page 1. Miss Crowe sends that on to you in April about postponement of the working group, but asked, does anyone know anything about the email being quoted below about remote alteration of figures in branch? That's the Wynne Lusher email. That's a new one. I think that's a new one on me. Can we chase Cartwright King for a response on the Rose report point? And then further up, you reply to her. You attach an email chain. I think that's the Wynne Lusher email chain. Is that right?
Yeah, that would be right.
In terms of corrections, transaction corrections and acknowledgements, that's the Helen Rose issue. We've explained these in the fact file, so it should be clear that these need the branch to accept. The TCTA on the Horizon systems, it doesn't automatically make any adjustments. What did you mean by that?
In terms of the transaction correction and the transaction acknowledgement, how they operated is what I've called out there.
So you're saying on the transaction stroke acknowledgements issue, that's the Helen Rose report issue, we've explained these in the fact file.
So the transaction correction, transaction acknowledgement wasn't anything to do with the Helen Rose or the Lepton scenario.
That's a separate issue again, is
Yes.
it? Okay, my mistake. What happened then in relation to the issue that Howe & Co were raising concerning the Helen Rose report?
So Belinda picked that up and said, where are we with Cartwright King on that one? What I was bringing to the attention of everybody here was this was the issue around the Wynne and Lusher. I think it was Alan Lusher. That's the bit that he's referring to there.
But so there's three things going on then here. One is the Wynne Lusher email, one is the TCTA issue,
Yes.
and the third is the issue raised or addressed in the Helen Rose report concerning the Lepton Branch.
Yes.
What happened to the question or the assertion made in Mr. Darlington's email that the Helen Rose report is of critical significance to all cases? What did you do as a result of that?
So I didn't do anything with that. Belinda picked that up. To scroll down, Belinda picked that up directly and said, where are we with that?
Okay, and why was that Belinda's responsibility?
So Belinda was part of the Project Sparrow team. And as I said yesterday, we didn't have defined roles. We'd never defined each person's role within what we were doing. But mine was predominantly the cases and the investigation, and the rest of the team, and the legal team, and Belinda tended to facilitate a number of those requests and keep an overview on what was going on.
I've already asked you about the remote access issues yesterday, and so I'm not going to go back on those again. Last question on the Lepton Branch issue. Were you involved in any discussions or decisions about the extent to which it should be disclosed to convicted defendants?
No.
Were you involved in any discussions or decisions on the extent to which it should be disclosed in ongoing prosecutions?
No.
And were you involved in any discussions or decisions on the extent to which it should be disclosed to the CCRC?
No, that was all done by the legal team.
Thank you. That can come down, thank you. Can I turn to my third topic then, which is setting up the mediation scheme proper? You tell us in your witness statement that you were a member of the working group and the initial complaint initial complaint review and mediation scheme. Is
Yes,
that right?
Correct.
And you tell us, I think, about your role in paragraph 114 of your witness statement, which we should turn up. And it's on page 60. You say that your role within the scheme and working group was to, and on behalf of POL, lead the team of case review advisors, investigators, who'd be carrying out the investigation and drafting of the POIR. Is that the Post Office's investigation report?
It is, yes.
It's the response to what Second Sight produced?
It's the response to the issues that came in from the applicant.
I see. Before Second Sight had produced its first draft.
So we produced the Post Office investigation report, passed that to Second Sight. They reviewed that in line with all the evidence and whatever other inquiries they undertook, and then they produced their case review report.
You had a North and South team, as you've told us already, with 10 case review advisors, investigators in each led by a manager. We've seen the name of one of those 2 managers for the North area. The managers sent each draft case investigation report for my review, and my review involved ensuring that each of the issues have been investigated, their findings explained in an easy-to-understand language, and that the findings were supported by evidence. My involvement in the scheme was prompted by my involvement in the Ferndown interview, but I wanted to take on this role, so I had a genuine desire to understand if there was any substance in the complaints. What motivated your genuine desire to understand if there was substance in the complaints?
Well, as we discussed yesterday, I'd had some rumblings over the years, and given that Horizon essentially was the backbone in terms of how we operated in our network, I wanted to understand if there was anything in the claims that it was Horizon that was generating the discrepancies.
Was it your view from the start of the mediation scheme, the formal mediation scheme, that the idea was to, at best, placate some sub-postmasters with token payments and apologies?
So when I started getting involved, it was about getting to the truth in terms of what had happened in the branches. There was an expectation, I think, within Post Office that we weren't massively exposed in terms of compensation payments, and I've seen some advice around what that would look like if we did need to compensate, which was, I think, in the range of 3 months' notice in terms of the remuneration, the contract. But there was never an expectation that there would be a huge liability in terms of compensation, yes.
That's the answer to a different set of questions, which would have been, what legal advice did you receive as to the extent of the liability exposure of Post Office? The question I asked was it the plan from the beginning of the mediation scheme on Post Office's part to only offer token payments and apologies?
No, so it would have depended on the findings of the reports. So in terms of the investigation, so it was never the intention was always about understanding if there was anything in the issues and the complaints that were being raised at the time. So it was a genuine attempt to investigate those claims and to see what the outputs of that were.
So it was always and throughout a genuine attempt to get to the truth and pay whatever compensation was due, whether that was a small amount or a large amount.
So it was always my intention to get to the truth. The compensation element was separate from my consideration at the time.
Was it always, to your knowledge, is Post Office's intention to get to the truth?
Yes.
Can we turn, please, to poll 0010-0036? Poll 0010-0336. Sorry for the delay. Thank you. On the 24th of February 2014, this is, a meeting took place between Paula Venables, Chris Oyard, Ron Wormington and Ian Henderson, so the two directors of Second Sight, the CEO and interim general counsel. And this is Mr. Oyard's minute of it. We can see that from the second page. His name at the end of it. And if we just go back to page 1, please. The meeting was held at Paula Venables' request in order to discuss the progress of the mediation scheme with Second Sight. Paula Venables explained that there were a number of areas he wanted to discuss, including the letter of engagement, the pressure from SHEEX, that's the shareholder executive, the board and timescales. Overall, the meeting was friendly with what appeared to be real engagement by Second Sight. It was noted by Paula Venables that the projected level of claims was currently around 100, and I think that's supposed to be million, in response to which Second Sight noted that their back-of-the-envelope calculation was of the order of 25 to 50 million. Paula Venables observed this was a long way from the figures that were in mind when the scheme was established, which were much smaller and more of the nature of a token within an apology. It was the case that neither the board nor the shareholder executive would countenance the payment of large-scale amounts by way of compensation. So I'll ask you again, did you know at the beginning, at the establishment of the scheme, that the plan was to make payments which were more of the nature of a token with an apology?
So if I go back to the start, so my involvement at the start was before the scheme. So when I got involved, and this was about getting to the truth and understanding, it was the initial inquiry, which is the spot review approach. And my early conversations were with, I was part of the broader conversation with Alice, Paula, Susan, and a few others. And it was, we weren't talking about compensation at that point. It was about getting to the truth of the claims. This, as I covered off earlier, came in later into the equation. I wasn't aware of this note until this morning, but there was always a sense, and I don't know at what point, there was a sense that this wouldn't be a massive compensation liability for Post Office. It would be further, a lot less money than clearly what was talked about here. But I wasn't party to those conversations. It was just that's what was relayed to me.
You were or one of the main leaders on the post office side of the mediation scheme, weren't you?
Yes, in the working group, yes.
Were you the most senior of the post office representatives on the post office side of the working group?
No, that would be General Counsel.
Were you the next most senior?
So it was General Counsel, it was myself. Belinda would have been there as a secretariat role, and then we had Andy Parsons as, yes, so I would have been the only other post office person consistently throughout that process.
You adopted a leading role in the mediation scheme on behalf of Post Office, didn't you?
In terms of the investigations?
And
yes.
In engagement in the working group?
And engagement in the working group I did, yes.
Were you not told that Post Office's idea of what the scheme should be, how it should end up, was that small payments, more in the nature of token payments, should be the outcome, along with apologies?
I don't think so at the start.
So how's it happened that the chief executive is disclosing in this private meeting here of what the plan was, and you didn't know about it?
So I think at the start, then, as I said yesterday, the scheme wasn't designed entirely when we started it. It was designed through the working group. So I didn't have an awareness of what we expected at the start, the compensation levels to be.
So all bets were off. It was an open field. The payments could be small, large, or gigantic.
So from my understanding, we were generally entering into this with, we need to get to the truth, and therefore, if we didn't know what the truth was, how could we possibly have an outcome in mind? That was my understanding and my involvement. Now, as I said, as it went through, it became quite obvious within Post Office that we didn't expect the compensation levels to be large. And I don't remember the date that happened. Clearly, by this point, Paul is concerned about it. But I say I wasn't party to all of those conversations.
When do you say the start was in terms of formulating the scheme?
So the scheme would have been formulated. I think we opened up for applications in August 2013.
Yeah.
Prior to that, we've been doing the spot reviews. So that's...
Or were they related to the interim report rather than the scheme?
Yes.
Yeah. So in general terms, the scheme came after the interim report?
Yes.
Right. So at the start, the summer of 2013, and this note is February 2014. So within 5 or 6 months of the start, clearly this was the view of Miss Reynolds, wasn't it?
Yes, because at this
point...
point...
And you didn't know anything between the start and this point in time that was her view. That seems to be what you're telling me.
So what I'm saying is that at the start, we didn't have... part of the application process was that the applicant would actually say what they expected their claim to be. And that's what obviously would have been driving the 100 million figure that I think that Paul is quoting there. At the start, we didn't have any knowledge of what that would be. It would have just been what people guessed it might be. And clearly, Post Office was in a very different place to where the applicants were.
Yeah. So in summary, once it became clear by the submission of applications that some people were looking for very large sums of money, it became the view of the Post Office that was never going to happen, in truth.
Yes, that's what they didn't expect to happen, yeah.
And was that said openly to sub-postmasters?
No.
Was the mediation process instead presented to sub-postmasters as a means by which they could achieve compensation for the way in which their contracts were terminated and for losses that arose from contract termination, and that compensation was at large?
I don't think it was set out in those terms, and I can't remember what the communication was now, which would have been in the application process itself, but it was set out as a way of understanding the issues and to see whether we could achieve closure. I think there was a difference of opinion, clearly a difference of opinion on what closure looked like for Post Office and what that looked like for the applicants to the scheme.
Was this plan or belief by the Post Office that the scheme in operation would only deliver, at best, smaller token payments with apologies, ever revealed to Sir Anthony Hooper?
I don't know. It certainly wasn't revealed through the working group meetings. If he'd had private conversations outside of that, I wasn't aware at the time.
If Post Office's private view as to the nature of the scheme, as expressed here, was revealed neither to sub-postmasters nor Sir Anthony Hooper, would you agree that the Post Office acted in bad faith during the mediation scheme?
I think the post office view changed throughout that scheme. I think at the start it was genuine, and I think when it was obvious where the claim level was from the applicants, that post office view changed.
And when that view changed, as you would have it, we see that Ms Reynolds said that was the view from when the scheme was established. But even if the view changed, as you've told us, was that revealed to your knowledge?
No.
Do you accept from then on the post office was maintaining a charade?
Well, I think we still generally wanted to go into the mediation scheme to try and get some closure on those cases, and some cases did get closure through that. But there was clearly, and this was evident from the working group and the conversations in there, that there was a big gap there. So I don't think I'd say a charade, but actually there was a gap in expectation that was quite obvious.
Was it instead always the case, right from the beginning, that from the post office's perspective, the purpose of the mediation scheme was for the post office to put its own position to sub-postmasters, to tell them that there was nothing wrong with Horizon System and that their contracts had been properly terminated?
That was never my understanding, and had it been that, I wouldn't have volunteered to have got involved.
But was there a document or a written record of the post office's intentions or plans at the outset of the scheme for its operation? i.e. its tactics?
So are you talking about the actual scheme? Because
yes, the mediation scheme.
Because my involvement was at the start, and for my understanding, from recollection, is what happened is that we had the interim report. So we'd had a year of Second Sight investigating into the spot reviews. We had the interim report that I think came out on the 8th of July 2013, and in response to that, which is subject to a board meeting or some kind of meeting, out of that was born the scheme. And I don't recall a particular document, or there would have been some discussion in that meeting around what that should look like. But I can't remember if it was, I don't recall it being articulated around we expect it to be this, although I have seen some correspondence around expectations, but I can't remember where from.
Can we move, please, to poll 0019-9572? And if we go to the second page, please, and just look at the bottom of the first page so we can see. Thank you. An email from Mr. Bates to Ms. Reynolds at around the same time, so in fact the month before, headed concerns. I'm quite concerned about what I've been hearing recently about the Post Office trying to change the scope of the scheme in order to restrict the terms of the investigation and stop certain matters being discussed. I should make it clear that the JFSA signed up to the details as were discussed and documented last July and August, and alterations to what was agreed will result in JFSA withdrawing from the working group and the scheme. I don't know if you're aware of what's being proposed by the new Post Office members of the working group, but from what I can glean, it seems as if the Post Office are trying to hijack the process, which is something your minister assured me would not happen in her letter to me last September. I'd be grateful if you'd look into what's happening at present. The impression I am getting seems to be very different from the discussions we had last year. And then up, please. That's forwarded to you, asking to Martin and Belinda, copied to you, advising on a response, and then further up the page, please. We can see that Sophie, the public affairs manager, and just help us with Sophie, the public affairs manager, is that in media and communications, or is
Yes.
that something different? Okay, so media and communications.
I think so Sophie was involved initially, and I think Melanie Caulfield came in after instead of Sophie.
Was Mr. Bates right? By January 2014, was the Post Office trying to hijack the mediation process?
So I think it had changed. So again, Alan would be going back to the start, where we had brought Second Sight in. And when we went from the inquiry, which was a spot review element of it, into the scheme, then it was a much more narrow focus on, it was to do with the applicant's issues at a branch level, whereas initially Second Sight was looking a bit more holistically around the issues.
Was Mr. Bates right that the Post Office was trying to stop matters from being discussed?
In terms of, the different elements of it, then it had definitely changed in terms of the scope, had changed from initially at the start in 2012 to where we were when we went into the scheme. So this would have been, the scheme opened in August, it closed in November 2013 for applicants, and this would have been a couple of months afterwards. So from Alan's perspective, he clearly felt there was a significant change. We'd had a change of membership. He refers to the change of membership in the group.
Was that Chris Oyard coming on board?
So Susan would have left, as she said this week, and I forget exactly what date she said she left, but Chris Oyard came in as her.
From September 2013 onwards, was there a hardening of the Post Office's position from Mr. Oyard's arrival?
I think so.
In what respect was that hardening of the Post Office position manifesting itself?
Sorry, more focus on the specific cases and getting the investigations concluded in the individual level in a reasonable timeline. Whereas prior to the scheme, we had very little output from those investigations and the timeline drifted. So it was about focus on getting the timeline.
When you say more focused on individual investigations, you mean less focus on systemic issues?
I don't think so. I think it was more around, we had the applicants to come into the scheme. We had 150 that ended up being 136, and that's the focus, where I think Second Sight, from Chris's perspective, were drifting outside the branch issues.
Can we move on, please? Poll 0020 0717. This is a slide deck dated, as we can see, the 13th of February 2014, about the initial complaint review and mediation scheme. And it's an update for EXCO. So is that the executive team within the Post Office?
Executive committee, yeah.
Oh, I'm sorry, executive committee. Just help us. I think we've heard about a board, and then underneath it, an executive team. What was the executive committee?
I think it's the same thing, actually. The name changed several times. I would take that to be the executive director's level that reported into Paula, and then Paula reported into board.
So who would be on it?
No,
who would be on it?
Who would be on it? Sorry. It would be all Paula's direct report. So I'm sorry, I'm probably going to get this. In terms of the job roles, there would have been the CFO, there would have been the Chief Operating Officer, there would have been the CIO, Finance Director, the HR Director. So it was that broad level. Comms Director.
Can we go to the next page, please? There is an agenda for a meeting. Can you see that?
Yes.
Over the page, please. It records that the programme, that's the mediation scheme, is at a critical juncture with large potential financial exposure, with a very large expectation gap. Post Office has no hard power and minimal influence, and is paying at the bills. What was hard power?
I presume control from this.
Was that something that the post office wanted, hard power?
Not that I was aware of at the start.
Were you responsible, or did you contribute to this slide deck?
I don't believe so.
You were still at this time one of the senior leaders within the post office, responsible for the mediation scheme, weren't you?
In terms of the investigations, yes.
Well, and in terms of sitting on the working group, yes.
Yes, in terms of the working group as well, yes.
Was it your view that the post office had no hard power in the mediation scheme?
No, we never, I mean, when we set it up, it was never intended that we would have hard power or control anyway. I mean, we had an independent process running. And that
This seems to be written as a complaint, doesn't it? We have no hard power. We've got minimal influence over the way this thing is going, and yet we're having to pay for it.
But that was always the way it was set up. That was the agreement from the start. It would be independent. We would be footing the bill, but we would have no influence over the independent forensic accountants firm that we brought in. That was how it was set up.
Did you ever gain any information that the ExCo or the board expected Post Office to have hard power and proper influence on the mediation scheme?
I didn't at the time. I've since seen things disclosed and listened to evidence from other people, but I didn't at the time.
It continues in the next bullet point, hostile stakeholders, including those directly engaged by the Post Office. In the mediation scheme, who were the hostile stakeholders directly engaged by the Post Office?
Well, from this, it can only be a second sight, because we didn't engage any other stakeholders.
Were they hostile?
Not to my working knowledge. They were challenging.
Well, they were independent.
Exactly, which I expected them to be. They were independent, and therefore they were challenging, and they were looking at things through a different lens to what Post Office had traditionally looked at.
So how's it happened that the third bullet point has been constructed to brief ExCo for this meeting, and it doesn't represent what you believe to be the case? And the fourth bullet point too is saying that hostile stakeholders are second sight. So second sight are hostile stakeholders, and you didn't believe that to be the case either.
That wasn't my view. Sorry, who authored this?
Well, that's what we're trying to discover. That's why I asked you.
Okay, because it's not language I would use.
Are you trying to distance yourself from this, whereas in fact this was your view? You were rather resenting the fact that second sight were independent.
No, I wasn't actually.
You thought, we're Post Office, we're paying the bills here, and therefore we ought to be able to dictate the results.
Not at all. That was, as I said earlier, that's not why I got involved.
Susan Crichton dropped the ball by getting people who were too independent in.
Susan Crichton did her job by getting people who were independent. That was the whole point at the start.
And was forced out of the business.
Yes, but what I'm saying is Susan, when we had the early conversations about what we were trying to do, we wanted it to be independent, and that's why we went down the route of second sight, and they were doing their job.
The next bullet point, the working group was asserting itself and seeking to re-engineer its scope, or the scope of the scheme, presumably. Is that accurate too?
The working group, we were looking to get more focus on putting applications through the process. So we did become more focused around timelines. And that was it, really. I mean, The working group, I mean, it was a developing way of working from the start. And when Sir Anthony Hooper joined, which was about a month after, I think, in October, that's when we started to get the focus and get some shape to getting the outputs from the applications.
The author of this document is telling the EXCO that the process the process design was being driven by vested interests. Was that your view?
Depends what they meant by vested interests. The vested interest, from my understanding, was we all wanted to get the investigations into the issues done as quickly as we could. It took longer than we all expected because they were very complex issues and we didn't have all the information readily available to us. So that, I think, was the vested interest, is getting to the production of the reports, the conclusions, and then on to the next stage, which would have been the mediation.
If a person wished to brief the EXCO about the current operation of the mediation scheme in mid-February 2014, you would be the obvious person to turn to for information. Do you agree?
For information on the scheme progress, in terms of the applications, then yes.
Well, and the way it was working.
But this isn't the language I would have used.
That's a different question, Ms. van den Bogerd. That would be, is this language that you would use? And then you'd reply to me, that's not language I would use. I'm asking you a different question, which is whether in mid-February 2014, a person wishing to brief EXCO about the operation of the scheme would naturally turn to you.
I would have expected that to happen, but the content and the language here isn't my feedback. So I don't...
Did somebody turn to you in mid-February 14 to ask you, how is the scheme working?
Not that I can remember specifically. I would have been given updates on the scheme if I'd been asked to go into meetings to do that, and I would also have been given updates on the branch support programme that was running in parallel when I set that up as well, which would have been, I think from memory, that would have been August. It would have been just after the interim report, August 2013. So the main focus of my updating was around the branch support programme, but I would have been should have been consulted on how the scheme was operating from a case perspective.
If EXCO was to be briefed on the operation of the scheme in mid-February 14, whoever was briefing them should have come to you to ask.
Unless they thought they already had the information that they needed.
Who apart from you could have given it to them?
So it would have been people on the working group. So that would have been Chris Ojard, it would have been Belinda Crowe and myself.
Right, so there are three possibilities in reality, aren't there? Because whoever was providing this briefing had to come to one or more of you three to have any sense of what was going on.
Yes.
So I'm going to leave that there. Can we take our second 10-minute break?
Yes, of course.
It's a slightly compressed
Sure.
time in between, but it's
Yeah.
because of lunch and other things.
Of course.
Thank you. Can I move to later in 2014, please, Ms. van den Bogerd, by looking at poll 302-1762. And start by looking at page 3, please. And then scroll up, please, to page 2. Yeah, sorry, it was on page 3, actually, if we scroll down. Can you see an email there? We just scroll up a little bit. Thank you. And a bit more from Andrew Parsons to, amongst others, you, in July 2014, on suspense account, a paper, Second Sight. And Mr. Parsons says, Belinda Angela, as discussed briefly yesterday, I suspect the information requested by Ian below, that's Ian Henderson, is highly commercially sensitive. It may also be that the figures in question are quite high, and just stopping there, I think he's there talking about, is this right, the details of month-end balances and profit and losses.
Sorry, I didn't quite see the earlier.
Yes,
this is
I'm
about
trying to do this
at
some speed. Take
I
it
think
from
the
me
initial request was around the suspense account, and I think then Ian started to narrow the request.
The figures in question are quite high. This may then be portrayed as if there are significant sums each month that cannot be reconciled with the Post Office's accounts. The inference from this is that the Post Office's processes, accounting systems are flawed, given the volume of discrepancies. Whether or not this is correct, it's an easy leap to make. So was what Second Sight were saying was that they were seeking information of the amounts held in suspense accounts on a monthly basis?
Yes.
And also seeking information of where that money went into the Post Office's profit and loss accounts?
Yes.
Then if we can go up, please. And again. Second Sight have now come back, you're copied into this email as well, from Belinda Crowe, and asked for their information on the suspense account. Specifically, can we have details of the month-end balances for this account for the last 3 years, together with details of amounts released to profit and loss? And then you can see what's said in the following paragraphs. No need to read those in detail. And then up to the top of the page. And keep going. Roderick Williams says, I'd like to avoid giving anything, if at all possible. Less is more. Rather than give them the data they've asked for, we should provide management information which gives context, e.g. something along these lines, i.e. global figures rather than in relation to individual accounts, essentially. Is that right?
Yes.
This email chain informed you that significant sums each month were being held in suspense accounts which couldn't be reconciled with the Post Office's account. What was done about that?
So this was, Al Cameron was the CFO, Charles Cahoon, part of his finance team, and this was being managed with Al in terms of what we should and shouldn't be disclosing in terms of commercial sensitivity. So I think Al had met with, when are we, 2014, I can't remember the date. I think Al met with them at least once, maybe twice, and did produce some responses to them.
Is a summary of your answer, it was somebody else's responsibility?
So whilst I was copied into some of this, I wasn't driving this particular line with Second Sight. This was Belinda taking the lead on coordinating the responses from the finance team. I've never seen Post Office's suspense account.
I'll move on. Can we look, please, at poll 00307313? This is an email chain, again involving you, and also Ron Warmington, Chris Oyard, Belinda Cortes-Martin and Andrew Parsons, again regarding Second Sight's queries about the suspend accounts issue. And can we go to page 5, please? And scroll down. And sorry, just go up so we can see to the top of the page and the bottom of page 4. Keep going just so we can see it's Mr. Warmington's email. Hadn't realised it was this long. Keep going. Thank you. Mr. Warmington to Chris Oyard, Belinda Crow, copied to a mediation generic address. And this chain was forwarded on to you. And then if we scroll through it, please, I realise there's a lot of text here and the font is headache-inducing. Scroll down, please. And keep going. And stop there. He says our working group's chairman himself posed a question, which we hope we correctly recall as, could a surplus in one branch be offset by a shortfall in another? We're extending that question to, could a surplus that's booked into a suspense account in post office be offset by a past, current or future shortfall in any branch? And then if we keep scrolling, please. And keep scrolling. And stop there. And keep scrolling. And keep scrolling. And stop there. And again. So there's a lot of information, and stop there. I can't find what I'm looking for. In this email, I'll read it slowly. Mr. Warmington said, in the case of those credits to post office suspense accounts, the possibility exists that the amount that has been received was money that should have been remitted to a post office client or to one of the post office branches. Mm-hmm. Understand?
Yes.
And so what he's saying is that in the suspense account, there could be money that has been wrongly processed as a result of errors by branch customers, by branch employees, by the post office itself, or by a post office client. Yes?
Yes.
If we go to the top of the page, please, to page 1. And scroll down. And again. There's a suggested reply. In the third line of the first paragraph, Belinda Crow says, my initial take is that Second Sight still have not understood the points we've made or the way that the post office accounting system works. My only comment is as follows, and then scroll down a little further. I do not think it's appropriate to provide the source data, as it's not for Second Sight to trawl through a set of spreadsheets to try to identify what they might think is relevant. We will investigate the cases as and when they arrive. Why did the Post Office believe it was inappropriate for Second Sight to review data concerning the operation of suspense accounts?
Because I think initially it was thought that their request was too broad, which is why they met with the CFO to try and narrow it to get to more specific. So there was a reluctance on behalf of the CFO, I think, and Post Office generally to share the whole suspense account because it was commercially sensitive.
The information that Second Sight were putting to the Post Office disclosed a potentially serious accounting issue, didn't it?
That was the inference from Second Sight, yes.
Were the issues raised by Mr. Warmington in fact investigated by the Post Office?
Not to my knowledge.
Do you know why not?
No.
Would it concern you if there were credit entries from the suspense accounts that were eventually written off to the credit of the Post Office, i.e. its profit and loss account?
So my understanding, and I said I've not seen the suspense account, and that's not my area. My understanding how they work in Chesterfield is that before they take anything to profit, that they would have investigated those particular areas to make sure that it wasn't appropriate, applicable to somebody else. But this is outside of anything I ever did within the Post Office.
Even a non-accountant would realise that if money in suspense accounts was being attributed to the Post Office profit account
Yep.
wrongly,
Yes.
that's a very serious issue.
Absolutely, yeah.
Disputed money being added to Post Office's bottom line.
Yes. Agreed.
And that's what Second Sight were saying, weren't they?
Their line of inquiry was, is it possible that money that should be returned to postmasters was being taken to profit? I think, and that's my lay interpretation of what they were asking.
Thank you. Last set of questions from me, and it concerns briefing Ms Venables in the course of the mediation scheme. Can we look, please, at SSL 40116? This is a transcript of a telephone call, a recording of a telephone call between Ron Warmington and you about Carl Page on the 5th of January 2015.
Yes.
And I presume you didn't know you were being recorded at the time.
No, I didn't.
We have already heard a lot of evidence about the trials of Carl Page, his trial and his retrial in phase 4. And I think you've read this document, and in summary, Mr. Warmington was expressing his concern over the prosecution of Carl Page to you, wasn't he?
Yes.
If we turn up, please, page 7. You say at the top, and what he did, that's Mr. Page, is plea bargained it down to £90,000 odd. Mr. Warmington, I know that. I know all that. I know the whole case intimately. I've studied it in minute detail. What I'm saying is I still think, here's what I think the Post Office got this wrong, right up front. I think there was no theft of £282,000. The plea bargain down to 94 was because, and then you say, before you go on, how do you arrive at that conclusion then? Mr. Warmington said, I haven't, I've not concluded yet. I'm saying this is my hypothesis at the moment, which I'm trying to disprove. The problem I'm having is that everything I'm looking at in terms of the evidence is proving that my hypothesis is right, not that it's wrong, okay? What I'm seeing, even if you disregard the 650,000 and just talk about the 282,000, it looks as though Post Office concluded that there ought to have been £282,000 more in sterling or currency in that branch than there was, and that's correct. Because that's what the printout from both machines told us. Him, yes, yes. Well, here's my problem. When a bank does foreign currency dealing, bear in mind I'm intimately familiar with that because I used to be a foreign exchange dealer, both in business and for my own account, and I worked for many years in banks. Banks have multi-currency accounting systems. It's like the Ford money changer on steroids. So if you have, in a sterling-based bank, loans, and which are assets and borrowings in different currencies, which virtually all banks have, each of those foreign currency assets and liabilities is marked to market based on the spot rate at the end of each day. And the balance at the variation is processed into a foreign exchange profit and loss. Horizon is not a foreign current system, a multi-currency system, it's only sterling. The forward money changer has multi-currency accounts, but the evidence in the documentation shows that the totals in the forward money changer system are cleared every time a Command 10, I think, or every time a weekly report is produced. I strongly suspect that Horizon was maintaining a local currency equivalent of the foreign currency balances meant to be held, and by reason of doing that, it had basically come to the conclusion that there was more currency left in that branch than there really was. Why? Because he'd handed it all over to White House's bank account. It's all in that stuff. You can see he was running a balance in his current account with the best part of £400,000 at one point, and so he carries on. He was, policed in the subsequent. His first trial for conspiracy to defraud found no evidence of conspiracy between the two parties. It looks on the face of it that this ex-professional footballer, Page, was a complete and utter dope and was getting no particular benefit out of this. He was just handing it over. You say he was getting benefit out of it. He was getting, so we pay him a remuneration based on the value of sales. No, you don't. You pay him £1.60 per transaction regardless of size. That's in the evidence. But he would have been increasing his remuneration as a result of selling more. Bugger all. He gets £1.16. It was shown as £1.12 and then corrected to £1.16. Question, why was he doing it then? I'm coming to that. I can't see why he was moronic enough to be doing this. What I'm getting at is entirely possible in my mind he was getting some benefit that hasn't been disclosed by the court. However, the key issue is I do not see any evidence in any of the trials that any money at all was stolen. There's no evidence I've seen yet. I've still got about 1,000 pages to go through. I've seen nothing in the evidence or in the investigation report or anything else that convinces me that there was any money stolen. And then reading on, if we just scroll, please, and scroll, and scroll, and scroll, and keep scrolling. The discussion continues and keep scrolling, and keep scrolling. Just slow down the scrolling, thank you. Discussion continues, keep going, and keep going. You carry on discussing it, keep going, and keep going. You're continuing to argue it through with him, and keep going. And so it continues, okay? Mr. Warmington expressed the view to you, didn't he, that this was a case of a miscarriage of justice.
What he was saying to me is that he had information that we didn't have that was leading him into that conclusion, but he hadn't concluded his investigation. And I'd asked him through the conclusion of this exchange was, well, if you have further information, can you give it to us and we will reinvestigate? Because at this point, we had done the investigation and produced the POIR, which is then Ron's gone on to looking at all that information, and he said he had further information that he was considering that hadn't been disclosed to us. So the conclusion at the end of this conversation was, well, give me the information, I'll pass that on to the investigation team, and they'll do another investigation into this case.
That can come down, thank you. He was expressing his view very strongly that there had been a miscarriage of justice here and that the Post Office may have misled the court.
That's what he was saying, although he was saying he hadn't concluded his investigation. So that's why I said, well, give us the information and we will reinvestigate. And then that went back to Ron.
You were disagreeing with him and saying, we need to go back and investigate further. And he said, my draft report on this case is going to be damning for the Post Office, didn't he?
I think, well, I mean, that's neither here nor there from my perspective. The point was, if Ron had information that we had not taken into account when we did our investigation, then we should have that. And we basically were pushing the process back, I think I said 4 to 6 weeks. for us to look at that information and to see whether that affected our findings, and then pass that back to Ron for him to do his piece at the second stage.
He said that he had strong evidence of a miscarriage of justice, didn't he?
He was intimating that, but he hadn't concluded.
A few weeks later, on the 2nd of February 2015, you were sitting next to Paula Venables in Parliament giving evidence, weren't you?
Yes, at the Select Committee, yeah.
I'm not going to ask you about the evidence given by each of you because parliamentary privilege prevents me from doing so. But Ms Venables has subsequently stated in her second witness statement to the inquiry that as at that date, 2nd of February 2015, she had seen no evidence of any miscarriages of justice.
Yes.
Did you brief Ms Venables before the 2nd of February 2015 about what Mr Warmington had said to you?
No, because at that point we didn't have evidence. So Ron had an hypothesis and he was working through to conclusion. So at that point there was none. And the process that we were adopting as part of the scheme is that we would do the investigations, and then our legal team would actually look to see whether there was anything in those reports that questioned the safety of the conviction, and that was something that Chris Ojard was managing through and updated. I think it was around September in the working group that was happening. That would be 2014. So there was that safety net into the scheme process that we were adopting.
Thank you very much, Ms van den Bogerd. They're the only questions I have. So before I think we proceed to the call participants, there's an issue of the self-incrimination warning.
Yeah. So let me just get this straight. It's Mr Henry or Miss Page first?
Yes, it's the HJA team first. It is Mr Henry.
And can I just be clear before we embark on questions? Are there questions likely to be put by any co-participant which makes it either necessary or just desirable for me to give a warning about self-incrimination?
Desirable, sir.
Desirable. Well, that's enough for me. Ms van den Bogerd, you may have heard of the expression, a warning against self-incrimination. Indeed, I've given it on occasions at this inquiry. But if I can now give a formal direction about it, under our law, a witness at a public inquiry has the right to decline to answer a question put to her by any lawyer if there is a risk that the answer to that question would incriminate that witness. And we know this legal principle in shorthand form as the privilege against self-incrimination. I regard it as at least desirable, but more importantly fair, that I remind you of that principle before you answer any further questions to this inquiry. However, I should tell you that it is for you to make it clear to me that in respect of any question put to you, it is your wish to rely upon the privilege against self-incrimination. If, therefore, any of the lawyers who are now going to ask you questions put questions to you which you do not wish to answer on the grounds that to answer might incriminate you, you must tell me immediately after such question is put, and at that point I will consider your objection and thereafter rule upon whether your objection to answering the question should be upheld. Do you understand what I've said so far?
I do, sir. Thank you.
And are you represented today in the sense that there's a lawyer in the room who can assist?
I do, yes.
Well, if that's the case, that being the case, if this issue arises, and if you wish to consult your lawyer before going any further in the process, then please tell me that, and I will consider whether that's appropriate. All
okay.
right?
Thank you.
Right. I'm sorry to sound like a timekeeper, But you have 30 minutes, Mr. Henry, and since we're already past 12:30, I propose to take lunch at 10 minutes past 1,
Thank you, sir.
which gives you a slight margin of error, if I can put it in that way, which will be rigorously enforced.
Thank you, sir. From 2010 onwards, as you rose higher and higher in the post office, did you ever ask this question, that people had gone to prison and it was totally wrong?
No.
Did it ever occur to you from 2010 onwards that the ghastly prospect of miscarriages of justice was occurring on your watch?
Sorry, when you say on my watch, what do you mean?
Well, as you rose higher and higher in the organisation and as you were given more and more responsibility, did it ever occur to you that the prosecutorial policy of the Post Office was sending innocent people to prison?
No, I trusted that they were following...
Could you keep your voice up, please?
Sorry. No, I trusted that that function were following due process.
And I'm going to suggest to you that there are a number of compelling reasons, aren't there, why the answer you've just given, and in fact the evidence you have given already to this inquiry, oughtn't necessarily to be believed.
I don't think so.
The High Court litigation has left you with a credibility problem, hasn't it?
In terms of Justice Fraser's comments about me in the first trial.
It's not just because of what the judge said about your evidence, but because of what you said on oath. Can you not see that?
Sorry, I don't know what you mean.
Well, you're now tied to that account, aren't you? What you said in those two trials, you are now tied to, aren't you?
At the time when I made the statements, I believed them to be correct. I was cross-examined on both and made some corrections through that process as well. But yes, that was my evidence.
You are now tied to what you said on those trials, for example, in relation to remote access.
Yes, at the time I believed that to be correct.
You're worried, aren't you, that if you now admit that you knew about remote access way back in 2010, you'll be liable for perjury. Isn't that the truth?
No.
Let's revisit very briefly the remote access timeline. John Breeden's email to you on the 5th of December 2010, and it's POL 000-88956. But you remember it, don't you?
I don't remember receiving it or reading it at the time, which I've said several times yesterday.
When we get it up on screen, we can see further to my voicemail message on Friday, please find below the email I have received from Lynn Hobbs, then omit the next paragraph, go to the last two lines. I have two further emails from Lynn. I will forward. I will forward on one relating to Horizon Integrity, which Sue and Mike have already received, and the third providing a brief ahead of the meeting with BIS. And we can see further down, of course, there is the email that has been cut and pasted in, which you're familiar with because you were taken to it. Now, the information from John Breeden and Lynn Hobbs should have put you on notice of potential miscarriages of justice, ought it not?
Not to my understanding at the time, no.
The whole remote access to Horizon issue, referred to by Lynn Hobbs in her email of the 3rd of December 2010, which John Breeden forwarded to you, alerted you to a back door in the system, didn't it?
So it alerted me to that Lynn had raised her concerns to the IT team, and that she was waiting. She was waiting a further update.
So, when you say that, so it alerted me that Lynn had raised her concerns to the IT team, etc., etc. Are you now accepting that you must have read that email at the time?
No, I'm not. I've said that numerous times. This is from reading this email as part of this disclosure pack.
Right. I see. So your account is that you had a voicemail from Mr. Breeden about remote access, about the Lynn Hobbs email, but that didn't register, correct?
So that's not my account.
Well, it must be, because we can see from the document that I have just put to you, Angela, further to my voicemail message on Friday, please find below the email I have received from Lynn Hobbs. So it follows, mustn't it, in order for your account to be consistent, that he'd sent you a voicemail, left a voicemail, and that didn't register with you, correct?
So what I've said is I didn't read this. I don't remember seeing this at all. I haven't responded.
I'm asking you about the voicemail.
So if he left me a voicemail, I don't know what that would have said at the time, because I can't remember that far back. All I'm saying is I genuinely do not remember reading any of this context back in 2010.
Genuine's doing some pretty heavy lifting in there, isn't it, Mrs. van den Bogerd?
That's my recollection.
Are you being dishonest about this now, or were you inexcusably negligent at the time?
I'm not being dishonest about it. And had this registered with me at the time, if I'd seen it, I would have had a different outlook on what's come next, but I clearly didn't, because I hadn't read it at the time.
Right. So let us carry on, please. Are you accepting now, then, that you are grossly incompetent to have failed to have either read it or failed to appreciate its significance at the time?
I'm saying I've missed things over my time, but in this I didn't see this, and therefore I can't be incompetent if I didn't read it, because I wasn't aware of the contents of it.
So it was obviously on a matter of central importance that we see again and again and again, in fact, very, very, very briefly, a month later, but you don't register its importance either because you haven't read the email or because if you had read the email, you just didn't appreciate its significance, correct?
Sorry, when you say a month later, you're talking about the Tracy Marshall email?
Let's go then to the 5th of January 2011, Tracy Marshall. Tracy Marshall, POL 00294728. And we can see there that Helen Rose is copied in. So it's to Kevin Gilliland, to you, and to Helen Rose, and it's entitled Horizon System Issues. Helen Rose, of course, was dealing with the Lepton Post Office system reversal.
That was 2 years later than this?
Yes, but she was also copied into this, wasn't she?
She was, because she was looking at the data in advance of this meeting.
I see. And you're saying now, here in 2011, that you were not able to discern the significance of this email when you received it. You didn't appreciate its significance.
So what I've said, no, I didn't, and the reason that I didn't was because I had some assurance from what Tracy had said, and the messaging on remote access changed continuously across my time with Post Office. So I didn't, in terms of this one, the significance on anything to do with criminal convictions, I didn't understand the significance of any of that.
You didn't appreciate its significance. That's
No.
your evidence.
Yes.
Again, I ask you this. Are you being dishonest now or grossly incompetent then?
I'm certainly not being dishonest, but that is my evidence. I'm not being dishonest.
Interesting, isn't it, that the very next day you're in the Ferndown interview, again with Mr. Gilliland, and I suggest that the Ferndown interview of the 6th of January tells us all we need to know, that this was a deliberate cover-up of remote access. What do you have to say about that?
It wasn't.
And in fact, Mr. Baker of the NFSP actually uses the term remote access software in that interview, and you deny, don't you? You say, we cannot go in and amend. You knew that wasn't true, didn't you?
So I was talking about post office, and that is true, and to the best of my knowledge, that is still true. And the subsequent conversation about Fujitsu is that it would leave a footprint.
You didn't mention the material, or rather you say you didn't volunteer the information you were aware of, which you received from Tracy Marshall, because you didn't have the technical knowledge, and you said yesterday that you hadn't seen the John Breeden email. Do you still stand by that evidence?
Yes,
Again, I suggest that that's a lie.
I disagree.
Let's move on, please, to the Win Lusher email. And the Win Lusher email is POL 003 04439. And that's dated the 9th of May 2014. But if we scroll up, we can see that you, in fact, called for the Win Lusher email on the 14th of April 2014. But again, your evidence is that you didn't, a little bit further up, your evidence to the inquiry is that you didn't appreciate the Win Lusher email exchange as being significant either. Is that correct?
So I forwarded that to others for review on that, and this was in respect of a case in the scheme. So I'd asked for further information on the basis of this.
I'm not asking about you pushing paper or forwarding emails. I'm asking about whether you are maintaining before this inquiry that you didn't appreciate its significance. Yes or no?
I hadn't seen this before. In terms of this particular one, in terms of its significance, I don't remember. I know when I had it, I wanted to understand what was involved, and I'd asked for the information from Alan Lusher, which I got. I then forwarded it for further information and forwarded it into the investigation team for them to take that into account when they did their report.
I'm sure you did want to understand what it was all about. But you remember that you said to Mr. Beer earlier on today that by February 2013, you didn't have the knowledge base about the issue. So by this time, in 2014, had you acquired that knowledge base?
So anything I had with knowledge base from the IT, Horizon system and the IT, I got from the IT experts. I never had that knowledge of my own. I always relied on information from Fujitsu, whether it was via our internal team.
But you had to acquire it, didn't you? I mean, you're in a managerial role. You had to acquire it. What I'm going to suggest to you is that you are minimising your level of understanding before this inquiry, aren't you?
No.
Can we go, please, to POL 00116957? And can we go to page 6 of this document, please? We're now in December 2014, and we can see there Aveen O'Farrell, who is the executive assistant to Paula Venables, the chief executive, correct?
Yes.
And it's dated the 9th of December 2014 at 7:15 in the evening. It's received from Donna, so Donna sends it to Aveen. Angela V and Belinda Crowe are currently dealing with all Horizon integrity issues. This had been given to you. This was your responsibility, wasn't it?
No, this was very loose wording from Donna. I mean, this is all to do with what they saw as Project Sparrow, and everything came mine and Belinda's way.
That's another lie. Let's go down there. Let's go down to Aveen O'Farrell, 9th of December 2014, 15:28. She's the executive assistant. You've already accepted that, to Paula Venables. Please see below. Is this something you would deal with, or would Angela van den Bogerd? Paula mentioned earlier that any mention of missing money, IT fault, should be dealt with by Angela. You had carriage of this. You were sitting in the driving seat, weren't you?
Not for IT matters, no. Paula, as we've seen, will forward emails to me for some elements, but to the IT team for others. So that was not my area of responsibility in terms of IT.
Any mention of missing money, IT fault, should be dealt with by Angela. Nobody's suggesting that you've got a doctorate in information technology, but you had been given the managerial role. You were here to field it, to deal with it, weren't you?
In terms of facilitating things, I would have, but I've never been IT qualified, and everybody would know that within the post office, and anything like that in terms of IT specific I would get from the experts.
This all followed, I suggest, this responsibility imposed upon you by the Chief Executive Officer, Paula Venables, all followed on from the way in which you dealt with the Lynn Hobbs email of 2010, the Ferndown interview of 2011, and everything subsequently, didn't it? She knew that you were a safe pair of hands.
I can't speak for Paula.
Don't admit remote access. Don't put things in writing. Keep on message. Spin the company lines. That's what she knew about you. And that's what you revealed to her. You would do anything to protect the post office.
No, that's not right.
Let's go to POL 001-39181. This is, again, to do with Panorama. And let's just have a quick look at your... Yes, here we are. You to Mark Underwood. Mark Underwood's role, it encompassed various things. He was also liaising with the CCRC, wasn't he?
I'm not sure.
I see. Well, what was his role in this, please?
So Mark was part of Project Sparrow. He was working with Belinda, and Mark here was coordinating. So I'd asked him for some information, and Mark coordinated that. So he did reach out to Fujitsu on occasion to get the information, what was the relevant information for whatever query we had.
You knew by this time in 2015, I suggest it's absolutely clear, you knew about Helen Rose and Lepton and you'd even liaised with Gareth Jenkins about that, correct?
On the Lepton, yes.
Yes. And you liaised with him, no doubt, about automatic system reversals, which looked like they were being perpetrated by the sub-postmaster, but in fact they had absolutely nothing to do with the sub-postmaster at all, correct?
It was auto-generated by the system, yes.
Yeah. You knew about Lynn Hobbs by then, you knew about Tracy Marshall, you knew about Wyn Lusher. Could we turn, please, to page 3 of this document? Again, you're asking Mark Underwood, would you also provide Post Office response to what Richard Rolls said on the programme? Key discussion point on Monday. I'd like a robust response explanation of the mention of going in by the back door and altering the coding. I need a layperson's explanation on what all this actually means. Nothing to do about admitting it there, is there? You had all of the information at your disposal to show that what Richard Rolls was saying was correct.
Not from my understanding, which is why I asked the question of Mark to reach out to Fujitsu to get the
Well,
response.
let's have a little closer look at your understanding by going back to page 1. Do you know the difference between right and wrong?
Yes.
Mark, there is another part of Richard Rolls and JS discussion that is relevant. JS, some people have been ruined financially, people have gone to prison. Is it possible that that suffering could have been caused because there are problems in the Horizon system? Yes, it is possible. What's your response, Mrs. van den Bogerd? Oh my God, could this be true? What are we going to do about it? No, it's any further comments, positioning on the above, please. What did you mean by positioning?
I just wanted to understand from what he said what the implications were, and I wanted an update so I was fully informed. I think this was going into mediation the following week.
You see, you knew, didn't you, and I suggest you knew from 2010, that remote access to sub-postmasters' accounts and the covert insertion of data was feasible, and that that would have brought down the entire prosecution edifice, wouldn't it?
As I've said, my understanding was it changed over the years, and I didn't make any link to prosecutions on the basis of my knowledge. That was information I was relying on the legal team to deal with.
You were deliberately suppressing the truth. You were allowing decent people to be prosecuted on the back of a flawed IT system, weren't you?
No, I would never do that.
You were letting wrongful convictions stand in the full knowledge that the IT system and the accounts could be manipulated behind the sub-postmasters' backs.
No, as I said, I didn't have the knowledge to be able to make that distinction.
And in fact, the sub-postmasters' ignorance of all this was the Post Office's strength, wasn't it?
No.
I'm sitting next to Mr. Parmod Kalia, the sub-postmaster of Chipperfield Road Post Office in Orpington in Kent. He'd previously worked for NatWest before taking on the branch in 1990. All went well for 10 years until Horizon was installed in 2000. Shortfalls started and he borrowed well over £20,000 from his elderly mother to cover them. And then in July 2001, an audit was conducted at his branch and a shortfall of £22,000 odd was found. Mr. Kalia paid back the money, but he was still prosecuted, pleaded guilty at Bromley Magistrates Court on the 17th of December 2001, and he was sentenced to 6 months imprisonment at Croydon Crown Court on the 8th of March 2002. Totally devastated his life, blew apart his family, had a severe and profound impact on his mental health, with effects too harrowing, even though he would allow me to tell you, but really too harrowing to disclose in public. And he now lives alone in a community centre. He wrote to your boss, Paula Venables, on the 21st of August 2015. And could we please put that up on the screen, please? POL 0014 1757. So POL 001 41757. Let me just, I'll just read a little bit out because I'm pressed for time. He wrote to Mrs. Venables as follows: knowing what you know about the Horizon system, and especially as it was a new novelty in 2001, surely you would agree that there are problems, bugs with the system that made cash disappear. I understand there's a team dealing with errors, creating false losses, and financial records were changed remotely without the postmaster's knowledge or knowing. I should be grateful if you could reopen my file and investigate the handling of my case. Could we go now, please, to POL 00119518. And this is your response. Can we scroll up, please? Because you signed this on behalf of your boss. Scroll down, please. Scroll down. Yes, there we are. All of the allegations that were presented on the Panorama programme have been exhaustively investigated and tested by the Post Office and various specialists over the past 3 years or more. The investigations have not identified any transaction caused by a technical fault with Horizon, which resulted in a postmaster wrongly being held responsible for a loss of money. What about Lepton?
Sorry, what do you mean about Lepton?
Oh, well, if you don't understand the question, I'm going to move on. It's a blatant lie, isn't it?
What is?
Let's go on to the next paragraph. There is also no evidence of transactions recorded by branches being altered through remote access to the system. Horizon does not have functionality that allows the Post Office or Fujitsu to edit or delete the transactions recorded by branches. It's a blatant lie, isn't it?
That was my understanding of what I've been provided with at the time.
Well, hang on a second. What's the date of this letter? The 9th of September 2015. From memory, and it may be that I've got it wrong, but yes, in answering questions of Mr. Beer yesterday, was it not before the 9th of September 2015 that a Fujitsu employee had confirmed that remote access was possible? I may have got the dates wrong, but it was certainly 2015. And you accepted that as from that date, or at least this is my take on what you accepted, that having been told officially by Fujitsu in 2015 that this was possible, that you accepted that information or should have accepted that information.
And that's correct, and it's actually in the next paragraph down.
Right.
Which is referring to the balancing transaction.
So it's the balancing transaction point, all right.
Yes.
I see it's the euphemism point, it's the Orwellian point. Truth is lies, freedom is slavery, ignorance is strength. We'll call it a balancing transaction so that we can get round remote access.
No,
Isn't that right?
No, that's not. That is that was the balancing transaction, which is what Sir Wynne was referring to,
Right.
which is the email from, I think, James Davidson from Fujitsu.
Well,
Yeah, that's what I had in mind, yeah.
Yes.
I've got one more topic, and I think I can squeeze it in 5 minutes.
4 minutes, Mr. Henry.
4 minutes. POL 000 27684. POL 000 27684. While that's being brought up, twice yesterday you denied any knowledge of a plan to eject Second Sight, correct?
I said I hadn't been involved in all the discussions, yes.
Do you accept that? Confirm, please, so it's completely unambiguous. You had no inkling, no knowledge at all of a plan to exit them from the mediation scheme?
No. I mean, I said I knew we were a business and not happy with the progress and the cost. But this is referring to me getting resource to be able to investigate the cases in the scheme.
Could we go to page 3, please? And I suggest that you're now wriggling on this issue, but I'll deal with it in this way. 13th of November 2013, 2206, hi Kevin, etc., etc. Go to the next paragraph. This is about the suggestion that the security team should be involved in the mediation, like putting foxes in charge of a chicken coop, I suppose. But anyway, these individuals have the experience and skill set required to investigate the cases and will be highly credible with Second Sight as we start to initiate their exit from the scheme. That would have been news to Second Sight, wouldn't it? That we're going to exit them from the scheme, 13th of November 2013.
Yep.
You were lying yesterday, weren't you?
No, I wasn't.
And in fact, you're lying again today.
No, I'm not.
As you have done throughout, I suggest. And my final question is, do you have any idea of the suffering you have caused, the many lives that have been blighted, with you contributing to that pain and that cruelty? Have you any idea?
I appreciate the level of suffering that would have inevitably happened as a result of prosecutions. I was never involved in the prosecutions, and my work has been trying to understand whether there was any issues with the Horizon system through the scheme.
Thank you, Mr. Henry. We'll adjourn now until what time, Mr.? 2 o'clock, Mr. Beer. Very well.